I'd like to welcome all our members here this evening, those in person here in Christchurch and also those joining us on the live stream online. Just a few society notices before I introduce tonight's speakers. So if you missed the April case law update, which was a lunchtime session, that's now available in the members area of the society website. On the 21st of May, there's going to be a particularly pertinent lunchtime webinar on the Middle East conflict and global fuel and freight disruptions, considerations for New Zealand construction contracts. Registration will be coming around shortly from Melanie, so you'll see those. And again, that's a lunchtime session. And then in Christchurch, there will be a in-person meeting on the 26th of May, which will be a presentation by David Wilkie and Mike Hansen, details to follow soon. So now to this evening's presentation, and we're delighted to have Janine Stewart and Rebecca Cook here to discuss adjudicator jurisdiction across jurisdictions and our regimes fit for purpose. So they've already presented in Wellington and Auckland, and tonight's their final presentation. So thank you very much to both of you for doing your tour around the country on behalf of the Society and presenting. Many of you will know Janine and Rebecca from past conference and meeting contributions. For those that don't, Janine is a partner at Minter Ellison Rudd Watts, specialising in construction, property and project disputes, and has led numerous arbitrations of significant complexity and regularly appears in various different dispute forums. And Rebecca is a senior associate also from Minters, specialising in construction law, and has significant experience in resolving large-scale commercial construction and energy disputes, including those involving building projects, and we're delighted to have both of them here this evening. Just one final comment before I go is that Janine and Rebecca do have a flight to go off to after this, so we will be wrapping up at 7 o'clock so that they can go, but there will be time for questions at the end. So I'll hand over to Janine and Rebecca.
Thank you very much, Julia, and thank you for joining us for our third time presentation on this topic. We were saying earlier we had a very lively audience in Wellington, including a couple of adjudicators that made it sometimes tense discussion in terms of some of our points and the approach of adjudicators to this issue. In Auckland, we had a very large crowd. They were a bit more quiet, but they became more lively afterwards, which sometimes tends to happen. So let's see how you go. As Julia said, I'm Janine. I am at Minter Ellison Rudd Watts, and I lead our firm's board. I'm also a partner in disputes and advisory work, so frequently advise mid-project in adjudications and then arbitrations. So I tend to be more in the alternate dispute resolution space, but I have my fair share of High Court experience as well, as I'm sure many of you do. This paper and seminar was drawn from a paper that Rebecca and I prepared in 2021, where we were really interested in how adjudicators' jurisdiction differed across the world, and also how common adjudication was in different forums and how effective it was in resolving disputes. And we were particularly interested in that time, given the COVID epidemic and the various supply issues and disruption issues that were occurring in projects at that time. And so we prepared a paper, which I think is probably available online, but if you want it, we can make it available, that looked at how common adjudication was across jurisdictions, but also whether it had become more common in light of the COVID epidemic. And I think based on the work that we did at that time, we decided that it certainly was. The topic came up again when we went to South Korea at the end of last year to present on adjudicators' jurisdiction across the world. We did update the paper, and then we also sort of paid close attention to how commonly adjudication was taken up across the world, including in South Korea. We did some interviewing there. I was on a panel at the Society of Construction Law conference that focused on alternative dispute resolution, and I was on a panel with some great speakers, Sean Gibbs, who is a FIDIC president, list adjudicator and mediator, and he runs Hanscom International Limited, which also does arbitrations and basically specialises in construction disputes. Murray Arms, who is a dispute board representative, who's also He's got a diploma in architecture, he's a quantity surveyor, he is a FIDIC arbitrator, he was very experienced, and he actually sits on dispute boards not only in the UK but across the world. So he was very interesting. And finally, Brendan Bowles, who's a partner at a Canadian law firm specialising in disputes and litigation, and who spoke on dispute boards. We covered in that session most of the alternative dispute resolution forums, from arbitration, adjudication, mediation, and dispute boards. But I think it's fair to say that the dominant focus was on dispute boards and adjudication, and actually even more so on dispute boards. And I thought that was interesting because whilst we've spoken about dispute boards a lot in New Zealand, it's not a commonly utilised form of resolving disputes during projects. We may have the odd one, for example, on the NZICC. I know there was a dispute board on some FIDIC contracts, there are dispute boards, but they're quite few and far between. And what came out of the panel was that they can be relatively effective in ensuring that disputes don't escalate across projects. And so it did cause me to question, and this is an invitation for somebody else to take up this topic and travel the country, as to why they're not so heavily utilised in New Zealand and whether they should be. Questions that came up in my mind were, do we have sufficient projects with sufficient value to justify the cost of a dispute board? Are we just sort of culturally wedded to more adversarial and traditional processes? And finally, do we have a sufficient pool of experts that can sit on these panels without having to go overseas to get them? Perhaps then that's why adjudication is more popular in New Zealand than in other jurisdictions, because we don't traditionally use dispute boards, and that's our topic for today, so we'll turn to that. We're going to cover adjudication and jurisdiction. What do we mean when we talk about these concepts? The adjudicator's scope across different jurisdictions, the New Zealand, the UK, Australia and Canada, and we'll also touch on how adjudication is utilised in South Korea, if at all, which is where we were. Rebecca's going to talk about jurisdictional issues that arise, how effective it is across jurisdictions, and whether adjudicators are able to award damages and consider common law remedies, which I'm sure Julie is going to be interested in. So turning now to what do we mean by adjudication and jurisdiction, and I've said this in the last two sessions. The last time I presented on this topic specifically was for Amons, and I was presenting with John Walton. I don't know if any of you know John. He despises jurisdictional challenges. He thinks they're a strategic tool and he gets very impatient by them. So it was another fairly tense presentation, but John and I get on well. That if any of you know John, he's not a fan of them, and if you're ever going to raise a jurisdictional challenge where John's your adjudicator, you better have all your ducks in a row and have some very clear logic behind it. He smells a rat on strategy. But first of all, what do we mean when we talk about adjudication? And I'm sure that many of you are familiar, but let's just all get on the same page. Adjudication is a process in which an independent third party, known as the adjudicator, determines a dispute put forward by opposing parties. In New Zealand, Australia, the United Kingdom and Canada, it is a statutory right, meaning that you can't contract out of it. And jurisdiction defines the scope of an adjudicator's authority, determining what they may hear and ultimately determine. As I said earlier, jurisdictional challenges are commonly used as a strategic tool, and Rebecca's going to talk a bit more about that, and I'll talk a bit more about that at the end. The fact that you've got a strategy behind raising a jurisdictional issue is not in itself fatal. The key is to make sure that there is merit behind the argument before you run it, and we've got some examples of where there have been some meritorious challenges and where there haven't been. Interestingly, over the years in New Zealand, the scope of adjudication has broadened as the scope of what constitutes a construction contract has broadened and what might be determined by an adjudicator. So for those of you who remember back when the Act came into force in 2003, the scope of the adjudicator's jurisdiction and what could be enforced in terms of what was decided was fairly limited to payment disputes, similar to Australia. And any determinations on rights and obligations were generally not enforceable unless they dealt with a payment under a contract. That changed in 2015, where the Act specifically broadened to allow the adjudicator to determine rights and obligations, and there was an enforcement mechanism introduced in the Act to enable those decisions to be enforced. At the same time, the definition of what constitutes a construction contract was significantly broadened to include a number of consultants. And for those of you that are familiar with standard form consultant agreements, you'll know that the general standard of care in there is sort of akin to a negligent standard of care. What would a reasonable party have done in these circumstances? Which opens opens the gates to a lot of evidence that an adjudicator will have to consider if there really is a dispute about whether somebody has met a standard of care in the contract, resulting in the need for payment. Just on this topic, and I suppose it goes to the fitness for purpose of our regime and whether we're happy it's been broadened or not. I was in a discussion with Paul Heath, KC, a few years ago, where he expressed frustration on the breadth that adjudication has come to in New Zealand. He sat on the original committee that's reshaped the legislation and was very focused on the purpose of the Act when it first was introduced, which was very much to facilitate speedy payment and to get easy disputes dealt quickly, as opposed to the more complex disputes. He's sort of horrified to hear about 20 Eastlight folders that you can be served with when you're served with an adjudication that are now being determined through this process. On the other hand, there are other commentators and academics in the industry that have welcomed this change. Contractors have not typically had such access to justice, so to speak, because it's been so expensive to run an arbitration if that's what's in your agreement, or run a high court proceeding, and adjudication opens the doors to faster and cheaper decision making. So there's two sides to the coin, and it's a question for us all to consider. I think one of his main gripes, which I think stands, is that the process is so tight that it doesn't lend itself to proper consideration of the types of claims that could fall within it. And that probably leads to broader consideration, and we can talk about this at the end, about whether we need to extend some of those timeframes depending on the nature of the dispute that comes before the adjudicator. Right, so how is adjudication used across jurisdictions? Now, a caveat to this table, it's almost impossible to find a set of data that comes from the same time period within these jurisdictions. So bear with us, we've taken snapshots across the jurisdictions, but they come from different time periods. So just bear that in mind. So in New Zealand, the Building Disputes Tribunal confirms, and certainly mine Rebecca's practices would confirm, that adjudication under the CCA is probably the most common form of dispute resolution for construction contracts. I say possibly comes second to the engineer process under 3910, which I'm sure we all deal with commonly. But if it escalates beyond that, adjudication would be the most favoured in our experience, and certainly that's the view of the Building Disputes Tribunal. Some interesting statistics, data from 2022 to 2023 confirmed adjudication cases were growing. And between 2008 and 2022, jurisdictional challenges occurred in 14% of claims. However, only 2% of those were successful, which is very low. In Australia, based on data from 2013, almost 2,000 applications per year. And in 2013, jurisdictional challenges occurred in approximately 10% of claims, with 48% of those being successful, which is high compared to New Zealand, although the number of challenges are not as high. In the United Kingdom, between 2,000 to 3,000 adjudications per year, and between 2011 and 2022, challenges were raised in 23% of cases, with 15% of jurisdictional challenges being successful. So highest number of challenges, but in between in terms of the number of success of those challenges. In Canada, and I'm going to talk a bit about Canada because we were given some helpful points from Brendan and his partner who appeared with us on the panel about the development of adjudication in Canada. So it's largely in its infancy. It was only introduced in 2019 in Ontario, and I'm just going to read through some of the points that Brendan has provided us with because they are interesting. So a high-level summary of adjudication in Canada. 4 out of 10 Canadian provinces have statutory adjudication. As of 2026, 3 more are looking to implement. In Ontario, the largest province by population, this was the first to introduce statutory adjudication in 2019. Initially, there was low uptake due to adjudication only being available for new contracts, not existing contracts, and the COVID-19 pandemic in 2020 to 2022. And this is interesting because for those countries that were familiar with adjudication, like the UK and New Zealand, it became a more commonly utilised tool. But for Canada, who didn't have any experience in it, it actually slowed down the uptake of it. It's an interesting observation. Since then, the number of adjudications in Ontario has increased significantly, and as of January 1st, 2026, amendments to enabling statute, the Construction Act, have refined and expanded the process, including allowing private adjudicators Initially, the scope of adjudication was more limited, but recent changes have allowed have basically extended the scope and have extended it beyond the original fixed statutory categories. The adjudicator's jurisdiction is governed by the Construction Act. They must be qualified by the provincial authority to act as an adjudicator and must be listed on a registry. Now, I'm interested in whether the Canadian legislation, and I have to admit I haven't checked this, is any more prescriptive than ours in terms of what an adjudicator must have to qualify to be an adjudicator, and we're going to talk about that a bit later about whether that needs to change. Finally, on this slide, I should say Rebecca and I visited a number of South Korean law firms while we were over there, and we questioned them about, what was the favoured form of dispute resolution over there. And our observation was that the public courts were the most favoured form of dispute resolution. That was largely encouraged by government, who want to see open cases and to have transparency over what's happening in the industry, particularly given the amount of government work that is happening over there. There were arbitration teams that had been sort of recently developed and were growing, particularly focused on international arbitration. But adjudication, it's not a statutory mechanism in South Korea, and even though there are sort of private ways that you could run adjudications, they were not particularly favoured. And I think that's what our discussions were, that that was largely due to the government not favouring private forms of dispute resolution, but encouraging parties to go through the public routes. That's an interesting observation across jurisdictions. So what can be referred to adjudication? So in New Zealand, we have talked about this. Originally, it was more limited. Now, disputes regarding payment and rights and obligations of a party under construction contract may be referred. This can be extended by agreement between parties. Now, Australia has seen quite a lot of change in their legislation governing adjudication, and we are seeing the nature of disputes that can be referred to adjudication broadened. But typically Australia has been much more restricted than New Zealand and the UK, and it still is. It's still largely limited to what's been claimed in progress claims. But in Victoria, recent legislation has now extended that to include claims relating to latent conditions, which is quite a change from what has historically been in Australia. And I think what's important to understand is, even though we say Australia is limited to what's in progress claims or payment claims, there are a number of issues that can be raised in those claims that relate to variations, extensions of time, etc. And that's commonly what we see in New Zealand as well. So it's not quite as restricted as it seems on its face. I think the important point to note is that in most states you can't extend the adjudicator's jurisdiction by agreement. In the United Kingdom, any dispute arising under the contract and as further determined by the parties' contract, that's the broadest jurisdiction. And I've already talked about Canada. Generally, payment disputes, valuation of services or materials, and any dispute agreed by the parties. But we are looking at that extending in Ontario specifically. So how does it look across the jurisdictions? How do they compare? There is a common objective to facilitate timely payments and efficient cash flow, but the scopes are different. The scope of jurisdiction in the UK appears to be the broadest, followed closely by New Zealand and Canada, although Australia is not as far behind as we initially thought, particularly based on the latest amendments in Victoria. This is a summary of essentially what I've just talked about, the scope of adjudicator's jurisdiction across the world and these jurisdictions. And there is also a discussion there about challenges, which Rebecca is going to pick up on as well. So over to you.
Okay, so let us now turn to how jurisdiction may be challenged in practice. So there's essentially two key junctures at which you might raise a jurisdictional challenge. First is at the outset of the adjudication, so maybe when the notice is served or the claim is submitted, or alternatively once the adjudicator has issued his or her determination and you're at the enforcement stage. And looking at New Zealand, if the jurisdictional challenge is raised prior or at the point of the commencement of the adjudication or during the adjudication, the adjudicator has jurisdiction to rule on their own jurisdiction, so they'll make a decision on it. In practice, you might see the respondent first writing to the claimant and raising the potential jurisdictional challenge, maybe seeking withdrawal of the claim, or potentially looking to leverage the potential jurisdictional challenge in exchange for maybe an extension to the response timeframe. Or alternatively, you might see the respondent writing directly to the adjudicator raising the challenge. At that point, the adjudicator will need to decide whether he or she is going to make a ruling kind of as a preliminary issue determination at the outset, or wait for the substantive determination itself. And it depends on the dispute, and it depends on the challenge as to what they may or may not do. Andrew Skelton has prepared a paper because he's previously a very commonly used adjudicator with lots of experience in this field, and he has written a paper which he presented to Admins a few years ago for adjudicators as guidance as to whether you might do it at the outset or wait for the substantive determination. In New Zealand, if the dispute has already been determined, you've got the adjudicator's determination, then a party may challenge it by way of judicial review. So although judicial review is available in the usual way, the courts have been very clear that in a CCA adjudication context that there will be a real reluctance to interfere with the adjudicator's determination and jurisdiction. The Court of Appeal in Rees and Firth, which is one of the leading decisions in this space, has specifically warned against judicial review proceedings that interfere with the pay now, argue later doctrine. So again, looking to preserve that objective. In the UK, the approach is similar to New Zealand, with those two key junctures at which you might raise a jurisdictional challenge. If you're raising it at the outset, a party may also refer the jurisdictional dispute to another adjudicator or to the courts, but that's pretty uncommon in practice. Or alternatively, they can refuse to participate, which I would also say is pretty uncommon in practice. The difference in the UK is that if the jurisdiction is challenged after the determination, you may still make an application for judicial review, but the UK courts have confirmed that other grounds, such as errors of procedure, fact, or laws, other judicial review grounds for challenge, are unlikely to be valid. So that's a bit narrower than New Zealand. In Canada, slightly different. Ontario, our friends, they have let us know that challenges must first be raised with and resolved by the adjudicator. So don't wait for the determination. As of this year, any objection that a matter is outside jurisdiction must be made by a party when it first makes submissions in the adjudication. So raise it straight away or don't raise it at all. So seems relatively fair. Then in Australia, it's quite different again. There's established procedures for review, which is set out in the legislation, which varies by all the different states. A couple of examples. We see in Victoria that a respondent can apply for review, but only if they've provided a payment schedule within the required time frame and have paid the undisputed amount. In Queensland, a party must first seek an internal review, then a review of the original determination to the registrar. Then in WA, a claimant or respondent can make a review application with the review adjudicator either confirming or quashing and remaking the determination. So quite a different process we see happening over in Aussie. But across all the jurisdiction, we see a pretty consistent theme. You can challenge jurisdiction, but you most certainly face a reluctance with the desire to preserve that pay now, argue later principle. Speaking from my own experience in practice, both raising and defending jurisdictional challenges, in New Zealand, I've found that in most cases, parties will raise the challenges right at the outset rather than following receipt of the determination. Sometimes there have been valid grounds for doing so, particularly where the notice of the claim is poorly drafted, perhaps by a layperson. And I'll speak to some of the common challenges in a second. But that said, and as Janine's already alluded to, quite often it's used as a strategic tool, perhaps with a valid reason behind it, but usually as a strategic tool, perhaps to negotiate an extension to the response timeframe, which is 5 working day turnabout. If you don't get an extension, it's very, very tight. It may be to distract the other party when they're under pressure, particularly if you know they're resource constrained. or to lay the groundwork for a later challenge or commercial settlement if you're expecting an unfavourable determination. So lots of factors that may tie into it. I've also been involved in situations where parties have looked to challenge jurisdiction following receipt of the adjudicator's determination by way of the judicial review pathway, but more often than not, a party that's dissatisfied with the determination will go down the arbitration route or High Court, depending on what their agreement provides. Practicing in London, it was a little bit different. I found that jurisdictional challenges were raised much more readily and equally at the outset and following receipt of the determination. When it was raised at the outset, this was pretty much always to negotiate an extension to the timeframes because they are more tight and constrained in the UK than here. When it was raised after the determination, it's pretty much always to be a difficult person or party. Actually, it was quite interesting observation working in practice when you're coming up to the deadline for receiving an adjudicator's determination and payments still come in a couple of days before you start preparing the papers for the TCC for summary judgment to enforce the determination. So very, very common to not comply with an adjudicator's determination in the UK, whereas I think here generally parties will comply even if they do seek to negotiate something after or push it forward to arbitration. In the UK, I found that if they did go down the enforcement route through summary judgment or through judicial review, pretty much always jurisdiction was found to be valid. So it really was a tactic just to delay payment and be difficult for a bit longer. That said, even with the court's reluctance to intervene, it's certainly true to say that jurisdictional challenges do arise. So let's look at some of the common ones. I'm sure there's plenty of others as well, but in our experience, these are the most common ones we come across. The first one is that parties may seek to argue there's no dispute and therefore no right to refer a matter to adjudication, perhaps where a claim has not yet been rejected or where a party says cannot admit or reject because there's insufficient information, or perhaps because the contractual claims process hasn't been followed or completed. This is commonly referred to as there being no crystallised dispute. Whether you've got a crystallised dispute ultimately depends on the very, very broad definition of dispute, which lays in all the jurisdictions legislation. But if I could refer you to a UK case called AMIC, Civil Engineering and Secretary of State for Transport, the court there set out 7 propositions to help guide what does and does not constitute a dispute. But in short, they said a dispute will not arise unless or until it emerges that the claim is not admitted, established either expressly or by inference, but not necessarily by reason only of the claim being submitted. So somewhere in the spectrum between you've submitted a claim, you may not have heard anything, and a very clear dispute. Another example is that the adjudication relates to multiple disputes. Parties have the right to refer a dispute to adjudication, so singular, not plural. So a party may look to argue that in the absence of consolidation or extension of the jurisdiction by agreement, the adjudicator doesn't have jurisdiction to determine a dispute. The UK courts, where this does happen a bit more frequently than here, have said whether there are multiple disputes requires careful characterisation, but essentially looking back at the factual background known to both parties. Interestingly, in WA, the courts tend to favour a more pragmatic rather than technical legislation-based approach. We've got at least one case where the adjudicator has allowed more than one payment dispute without the consent of the parties, provided doing so will not adversely affect their ability to adjudicate fairly and quickly, informally and inexpensively. So still maintaining that overall objective that the legislation is set to achieve. In practice, I haven't found this challenge to be particularly common. I think it's more common for the adjudicator to factor that into an extension to the timeframe for the response. Third example is that the adjudicator relates to previously determined matters. And we do see this come through in our case law a bit more common. It's a bit more complicated. So here, a party may seek to refer a dispute that has already been determined in another adjudication. In New Zealand, estoppel can be used as a defence where the same subject matter has already been determined to try and prevent multiple adjudications on the same issue. This was confirmed 6 years ago in the Haskell and Ashcroft decision, which involved 2 adjudications in an attempt to stop the third adjudication. In the UK, the legislation requires an adjudicator to actually resign expressly if they are presented with a dispute that has already been determined. I think the question of whether a subject matter has already been determined by an adjudicator isn't as clear-cut as it may seem. The courts have said the general rule of thumb is that a dispute will be the same or substantially the same if there are no material differences in the facts or the same documents will be relied upon. One of the cases in New Zealand, GK Shaw and Green, is quite an interesting example where it was held that a dispute had already been determined and was therefore barred. And it's probably a good lesson that you need to get your pleadings right first in the first adjudication because you won't get a second go. In that case, they'd sought damages, common law damages, and they could have actually reframed it in a way that potentially could get it under the contract, therefore within jurisdiction. And when they tried to correct it the second time round, that wasn't allowed. So get it right the first time because you may be barred under that jurisdictional challenge if you try to fix it. And another example is that the determination, once it comes in, is outside the scope of the notice or the claim. The jurisdiction of an adjudicator is defined by the terms of the dispute that it has been referred, as Janine's already mentioned, and the adjudicator generally can't make a determination beyond that scope. In the UK, it's different to New Zealand. In the UK, it's the notice, so the first initiating document that primarily defines the dispute, although the respondent can expand the scope of that depending on what they raise as part of their defence. Whereas in New Zealand, the grounds of the dispute set out in the notice may be superseded by the adjudication claim. The courts in Alaska Construction and Lahat in 2020 said that the notice of adjudication has no more relevance or significance than initiating the adjudication process. And our learned colleague John Walton has written in support of this decision. He said that the notice is to provide some general background, but this is not necessarily definitive of the arguments that may be raised in support of the claim. So look at the claim and make sure that's right. Wellington had some interesting debate on that. They said, well, surely you just can't change your entire position when you go from your notice to your claim. So I think there is some sort of boundaries there. You can't just completely recast your claim, but generally you can, expand it and fully ventilate your arguments, the claim itself, without jurisdictional issues. Another example, and it's a less common challenge, and it's not on the screen, is that the adjudicator does not have jurisdiction where one of the contracting parties is an international entity. This is a recent jurisdictional challenge that Janine and I have had to consider. It's certainly one you should be considering if you think any party to a dispute you have is an international entity. Section 25 of the Act contains the right to refer disputes to adjudication. Subsection 3 provides that a dispute may not be referred to adjudication without the consent of the parties to the dispute if, first of all, the parties have agreed to refer disputes to arbitration, so look for an arbitration clause. And secondly, the arbitration is an international arbitration as defined in Article 1.3 of Schedule 1 to the Arbitration Act. Make sure you look at that definition in the Arbitration Act carefully. Just because you don't have international rules such as ICC applying does not mean it's not an international arbitration. It can look on its face to be involving domestic arbitration, so look at that carefully. And I think our observation on that is as we get more international entities entering the New Zealand construction sector, this type of challenge will become more common. So stay alive to that. Touching briefly on whether adjudicators can award damages and if so, what kind. In New Zealand, we have Section 48(1)(a) of the Act which allows adjudicators to determine whether a party is liable to make a payment under a contract. Payment under a contract. Exactly what is included in this definition, particularly regarding common law, statutory and equitable remedies, is a little unclear in New Zealand, as we do not have definitive case law confirming either way or providing a bit of a pathway for everybody. We do have two cases of note. Haskell decision, which I've already mentioned. Here, the High Court rejected the argument that an adjudicator could only determine amounts payable under the contract. The court held that the adjudicator's jurisdiction extends to include compensation for loss or damages under a relevant statutory remedy. In that case, it involved an alleged breach of an implied term under the residential section of the Building Act, so an implied term from statute into the contract, and then the remedy relief available was still set in statute. So I think it got in there because the implied term made it something under the contract. Another case is the GK Shaw case, another one, it's the same case as these, where the court confirmed that common law damages for repudiation fell outside the adjudicator's jurisdiction. Yeah, so don't be bringing a claim under the CCLA without carefully considering whether you're entitled to, otherwise you might get a challenge on that front. There's another case here in blue, which is a very recent Irish case, and I raise it because it's very new, but also because it very squarely confirms that common law damages fall outside the scope of the adjudicator's jurisdiction. So I think we're waiting for a case like that in New Zealand. So that brings us to the question of, is adjudication still working? There's no question that construction disputes are becoming bigger and more complex, and jurisdictional issues arising in that context can be said to potentially impact the effectiveness of adjudication. There's three pretty obvious concerns that come with this, with jurisdictional issues. The first is the efficiency of the adjudication process, which can be severely compromised when you have constant timetable extensions, whether they're granted by the adjudicator or agreed between the parties, particularly under threat of jurisdictional challenges, just to get the process complete. Another concern, is the cost of adjudication can increase significantly because of the time spent by both the legal teams on both sides and the adjudicator raising and responding to jurisdictional challenges at the outset, forcing or avoiding enforcement of a determination towards the end, or even going as far as seeking judicial review and going down the advocacy route. I think the court's reluctance to overturn determinations does reduce the risk of legal escalation, but based on practice, certainly in New Zealand, I think it's not going to stop parties raising it at the outset, even if they fall short of going down the judicial review avenue. And third and final is the concern of whether a sufficiently robust interim decision can be achieved, which is really what the overall objective of adjudication is, interim decision. This can be undermined by restrictions on extending the statutory timeframes, so whether the parties can really put their best foot forward, knowing that they're probably going to get one decision. Again, the inability to re-adjudicate matters already determined, again, increasing the significance of that determination. So a lot of it hangs on what the adjudicator says. With that said, adjudication still is, in practice, remarkably effective, certainly in our experience, and I'm sure many of yours as well. I guess the question from our perspective is whether it could be working better and potentially for a broadened, more types of disputes. Back to Janine.
This is the fun part where we suggest recommendations and observations, which are very easy to do sitting on the outside and not as easy to do when you're sort of trying to legislate for these things. But nevertheless, it's helpful to think about where we can do better and how the regime is working. As I said earlier, an observation that jurisdictional challenges are used as a strategic tool, but the actual test is whether it has any merit or not. And there's a couple of cases I think that demonstrate a meritorious challenge and perhaps one that's a bit more complex and not necessarily so. The Horizon Energy and Parker decision by Justice France, as he then was, is a good example, I think, of a clear jurisdictional and natural justice challenge. So in that case, Parker had served a payment claim on Horizon, and Horizon had scheduled an amount payable, but it was less than the payment claim. So the dispute was over the difference. It went to adjudication, and the adjudicator decided she didn't need to decide the substantive dispute because the payment schedule was invalid. Now, that was an issue that was not put before the adjudicator. In fact, the parties had both agreed that the payment schedule was valid. So it was, one, not an issue in dispute, and two, not an issue that was put before the adjudicator. The other point that was raised from a natural justice perspective was that the adjudicator did not give the parties any opportunity to actually respond to that point because she'd come up with it on her own. So, in the arbitration context and adjudication, both are subject to natural justice principles. Appropriate notice must be given to parties to make submissions on the point that's going to be determined, assuming it would have made a difference. The other grounds of judicial review was irrationality, but that wasn't closely examined by the court. But the court upheld the challenge on the basis that the issue was not put before the adjudicator and that notice should have been given to the parties. And that is a fairly straightforward case, I think, of where you'd be on credible grounds to raise a challenge. The other one that's interesting is the Shaw decision that Rebecca just spoke about. In that case, there were two adjudication determinations in issue, one by Robert Fisher KC and one by John Green. And Robert Fisher had declined to award common law damages for repudiation, but he did determine the underlying rights and obligations of the parties as he thought he was bound to do under the Act, and the court said he was meant to do that. That was the right thing to do. And John Green had said in his determination that the issue that was put before him had already been determined by Robert Fisher, and the party that had wanted John Green to determine what it thought was a new issue raised a judicial review. And so I think that the key point there was whether essentially the party had put the same issue to two different adjudicators but packaged it in a different way. And ultimately, the court found that that was the case. So I think the key point there is the manner in which a claim is framed is not going to be determinative of whether an issue has been determined by an adjudicator. So I thought that was quite interesting there. The other matters that came up were the fact that, the adjudicator has quite broad powers under the Act to consider any issues that are ancillary to anything that's put before them. But that obviously didn't help in the Parker decision because there was no way you could suggest that the validity of the payment claim was an issue between the parties. So I think it's useful to give some examples of success and unsuccessful stories. One of the points that we raised in our paper when we considered this was whether New Zealand should consider broadening the jurisdiction even further, more in line with the UK, and also allowing longer time periods for the provision of responses, replies, and rejoinder to enable more complex decisions to go before adjudicators, but more fairly so. So I think that's the discussion that I had with you earlier, which is if you're going to allow complex issues to come before adjudicators, we do need to consider whether the time frame and the framework is actually going to do justice to the ventilation of those issues. One of the points that we're particularly passionate about is the qualification and pools of adjudicators. And I came back from the Cayman Islands in 2008, and when I came back, adjudication was still relatively fresh, but we were still very much involved in it. And it was very hard to find an adjudicator that was sufficiently qualified to deal with the relevant dispute. You could count them on one hand. And so unless you got one of those adjudicators, you sort of lost all faith in the process, was my observation. And we've definitely come a long way since then. We've got a broad pool of adjudicators. We've got a diverse pool of adjudicators, but I still think we've got a fair way to go. Probably down to 3 hands in terms of the ones that you want on your case. But we still have to seriously consider the robustness of our appointment regime. Section 74 does provide that a person is eligible to be an adjudicator in relation to a construction contract if the person meets the requirements relating to qualifications, expertise, and experience as may be prescribed, if any, they've never been prescribed. So we don't have a regime that is legislated. What we tend to rely on are, the relevant bodies have criteria to allow adjudicators to be registered with them. And some, like the Building Disputes Tribunal, have a fairly extensive list of criteria to become an adjudicator with them. So we tend to use bodies based on reputation and what we know about their criteria rather than what's legislated by statute. So I think we've got some work to do there, and it's probably the strongest discussion that we had in Wellington around the need to improve that. Another point that I didn't raise in relation to Western Australia is that they've introduced legislation that gives a second shot at a payment schedule. So if a payment claim is served and a payment schedule is not served in time, the contractor must give a second chance to provide a payment schedule. And I'm sure contractors may not welcome that development, but I do think that it might be worthy of consideration given, the sort of pedantic disputes that we tend to have when a payment schedule might be served at 12:01 a.m. the next day rather than within the relevant day. And then we've got, we may have a very significant substantive dispute underlying that. And I don't think that that's the intention of the Act. I do think that the second shot payment schedule still gives effect to fast cash flow so long as it's a second shot within a short period of time to avoid, and often I think it's fair to say it's the residential mum and dads that don't really understand the legislation that get trapped into that scenario. So a second shot makes sense, but I imagine that would be vigorously debated in the industry. So with that in mind, I think that brings us to a close on our presentation, and interested to hear your views or any questions. Have any of you been involved in dispute boards?
Involved in them.
Yes.
Yeah, I was.
Okay.
They usually do be. And then when I came here, doing some construction adjudication as well. So I think my question is about the jurisdiction, about whether, so if an adjudication was been referred like that, basically it's good adjudication, and the payment claim is valid under the Act. Is there any question about the jurisdiction of the adjudicator determining merits of the claim under the contract?
So you if you have a situation where a payment claim is served and
It's invalid.
and it's invalid,
Yeah.
but the other side hasn't raised that it's invalid.
Yes.
I think based on the Parker decision, I think it'd be challenging for an adjudicator to delve into that. But in the Parker decision, they had expressly agreed that the payment schedule was valid. So I wonder if the situation would be different if there hasn't been express agreement. But if the point's not in dispute and the parties have engaged in the underlying issues to the payment claim, I'd still suggest it'd be difficult for the adjudicator to delve into the actual validity of the payment claim. But you could distinguish it from Parker, given, if they hadn't consented that it was valid.
Yeah, I think that's right. I think at the end of the day, a debt due based adjudication is quite different to the merits based adjudication.
Yeah.
Adjudicator won't look at the merits if there's a clear valid payment claim, which is accepted, and a clearly invalid payment schedule.
For example, if there's so I would raise it another question, like if there is if the payment claim isn't valid in the first instance, and then both parties argue about the merits of it's being scheduled. That's how we vote, I guess then.
I think that the obvious way that you'd be able to address the payment claim is if the other side raises it as invalid. But if neither party raises it as invalid and proceed on the basis that it's valid, then it's not an issue that's put before the adjudicator.
you're better off figuring out that it's invalid from the outset and then just going on the basis that they're entitled to monies under the contract, irrespective of whether it's a debt due.
It does put the adjudicator in a tricky position, though, doesn't it?
Yeah.
Because that you can see that there's a clear debt due based on the papers.
Yeah.
That'd be interesting to see where that would go in High Court. But I mean, based on what we know, I think it'd be difficult to determine that issue as an adjudicator if it's not put before you.
Yeah. And especially if it's mentioned in section 48, that, 48, there's a payment that is due in section 48, 1B, and should be dealing with the pages having the contract as well.
That's right. And if I was just thinking about how it would actually play out, because if that's what's been put to the adjudicator, which is the underlying merits, the adjudicator has to determine that. So even if they did determine it was a valid payment claim, but then had also determined the underlying merits, you've sort of done the hard work anyway in terms of, whether there's a justifiable reason not to pay.
They're off covering both grounds and just running merits and alternatives.
And I second your where notes there saying that office of adjudication. So when you're referring to dispute adjudicator, and then there's a claim, if basically superseded by the claim itself, rather than going to because not as adjudication, some sort of like, okay, we have a claim in dispute. So, but you don't have details there. So details will be in there.
Yeah, that's a good one.
Just with the last expansion of the jurisdiction, did that actually see a proliferation of claims? Like, was there a material increase?
If we go with those stats from the earlier slides, I think there was an increase. I don't know if it was as remarkable as might have expected. But I think it has increased. Yeah. And that's what the stats show, that it has increased over the last, so it was sort of 12 years. Yeah.
And would you say that our adjudications usually involve rights and obligations?
Yeah.
So what I'm seeing in practice is
Actually see less about a payment claim. And just it being in debt due, because in most cases, I think the lawyers can see the writing on the wall. Why would you go through an adjudication that's going to cost between $200,000 and $500,000, depending on what you're actually adjudicating about, if there's a very obviously valid payment claim about a payment schedule? I think we've almost moved beyond that and more into the rights and obligations space.
you're more likely to do a stat demand or write a letter saying this is what's going to happen, you're going to lose, because you will.
Yeah.
Your experience that some contractors perhaps keep submitting the same payment claim months in a row and just hoping that the engineer is going to miss one.
Yes.
Yeah.
Very common. Yeah. There's a lot of pressure on engineers these days. You have to have really good insurance in place.
You're aware of one challenge that is saying that it's been rejected 3 times, reasons were given, and submitted the exact same claim the first time, but payment schedule wasn't reissued again.
Yeah, I don't have the authority, but the courts have said you can reissue. So it doesn't matter if you've reissued it last month and get reissued it again. Yeah, you can. And I think if you just do nothing, you're still going to be in that debt due regime. But if you've said I schedule 0 and see previous payment schedule, I think you have a good argument that because you can within your payment schedule refer to other documents. So, doing nothing.
Pretty common for the whole variation list to sit in the back of the payment claim and stay there every month. I keep reclaiming it. And then refer back. Yeah. Often times.
Are you?
Actually, the question, when you talked about the jurisdictional challenges being used strategically and tactically, waste the other party's resources often, and with adjudications becoming more complex and sprawling, and like second serve of 20 estimates is the worst. But adjudicators are often reluctant to award costs, even though the cost of running an adjudication can be just as high as a high court or district court claim. Do you think that needs to change and needs to be more of a cost quality event kind of approach?
That's a very good point.
Very good question.
We're going to add it to our bullets.
Yeah.
No, I think it is a really good point. What I found is I'm seeing adjudicators award costs much more often, but they're sort of, they've got to be very creative in their reasoning in terms of how they're doing it, and, because it's pretty high threshold. So I've seen the awards increase in costs, but I agree with you. That's definitely warrants consideration.
Yeah, I think that's really interesting. I think the cost of adjudication probably needs to be addressed.
And if costs follow the event and if it can extend the timetable, it's essentially just a privatised court system. Not like,
Any arbitrations
yeah, exactly.
without a hearing.
And then you start moving further and further away from the original purpose of the Act. But we've also had projects in New Zealand escalate in scale, complexity, overseas contractors coming in. So, we've got to evolve. And I suppose it's not entirely private, given it's still subject to statutory regime, but so is arbitration, and that's private. So
Always subject to arbitration for us, on our base.
Yes, so thank you very much for coming and doing that. That was really interesting, and especially to hear about the research done across the different jurisdictions and how it's used as well was interesting, and your suggestions as to how it could change in the future. So I'm sure we've all enjoyed and taken something out of that. There is something on being sent by the society to you for your participation this evening and travelling down from Auckland.